The broadcast is now starting. All attendees are in listen-only mode.
All right, good morning. We are about to start this month's webinar series. Don't ruin your retirement. Avoid these grade divorce mistakes. My name is Brad Micklin. I'll go through some information in a minute. Just to note, I am recording this February 13th, 2023. So if you're watching this on any other date or in any other state other than New Jersey, the laws may have changed. It's quite possibly if it's a different state, they don't apply. I do try to give as much general information as possible so that it will be more applicable to all viewers. So let's jump right into it. This is me for those that have not worked with me in the past. My name is Brad Micklin. I'm the lead attorney and managing member of the Micklin Law Group, which is a law firm concentrated in empowering men and fathers in divorce, custody, and family law matters, with offices in Nutley, Montclair, and Saddlebrook, New Jersey. I have been honored to receive several client and colleague awards. I'm posting a few here, not to try to brag or impress people, but to impress upon you the wealth of experience I have and the support that I've had from my clients and my colleagues in my 25, 30 years of experience. I've also been honored to be a national legal consultant on various topics and various stations. Inside Edition, Fox News, Larry King, may he rest in peace, I-24 News, and many others. And again, I'm not trying to impress with my experience or background, but I do want you to know you can trust in my experience and in the care I have for the work I do. The problem when you go on social media, YouTube, or the internet, there's so much information, you just never know what you're getting. So I try to show as much as possible when we start that hopefully you can trust in the information I'm giving to you. So what do you need to know about grade divorces and avoiding mistakes? And there's a lot of information. We have a lot of slides and a lot of information. I will tend to go faster through some of them than others because the statutes in New Jersey are often just very verbose. So first, how to divide up your assets you've accumulated, especially if they are substantial. It's going to be the first thing that is important to look at. And in order to do that in New Jersey, you have to understand something called equitable distribution. So the criteria for equitable distribution is plentiful. So let me quickly go through some of them. The first will be the obvious, most important is the length of your marital or civil union. And throughout this, I'm not going to say or civil union. So whenever I say marriage, I'm also speaking of civil union. It just becomes a little repetitive after a while. Next will be obviously the age and physical and emotional health of the spouses. Next is the income or property that either of you brought into your marriage. Very important, it's going to be the standard of living that you've established. Another thing that I don't know if this is actually in the statute or not, but it's something that I always tell my clients to consider, and that is any written agreement made by the parties before, during the marriage. Obviously, people often have prenups, and the law of that has changed substantially in the last handful of years. I do have a separate webinar on that. But you may also consider a postnuptial agreement. Again, another topic that's a little too deep for this webinar. I have done videos on my YouTube page, and I think possibly my YouTube, which is Brad Micklin, M-I-C-K-L-I-N. Actually, maybe Brad M. Micklin. And my YouTube, www.micklinlawgroup.com, will have a lot of the videos that I reference in here because I can't go through every topic about everything. But there are videos on prenups and postnups, when and how to use them, how to make sure that they're more likely to be enforced than not. So after any written agreements, the courts will look at the economic circumstances at the time that you are dividing property or getting divorced. These are not the only ones. Now, the next slide I'm going to give to you is just going to have a wealth of information. I kind of consolidated into one slide for you, and that is the income and earning capacities, educational background, employment skills, work experience, absence from the job market, custody, responsibility for the children, time necessary to increase education or training, standard of living comparable, and or to get the standard of education or training to rise to the level to be self-supporting at the standard enjoyed during the marriage is what that slide is supposed to represent. The courts will also look at the contribution that either of you placed or contributed to the other in his or her acquisition of higher levels of education, earning powers. That is commonly called reimbursement alimony. Another topic not covered directly by this, but in webinars that I've done in the past. Moving on, because there are still more things that you need to consider. Obviously, equitable distribution. Integrated divorce is going to be a significant topic because more often than not, or more often than in shorter term marriages or marriages of younger individuals, they may not have acquired the wealth of assets and the complexity of them, both from the type as well as the tax consequences, which we'll also talk about. Which leads us into the next point of equitable distribution criteria is the contribution of each to the acquisition, dissipation, preservation of the value of the marital property. And what's important inside of that is acquisition and appreciation, obviously, but also dissipation or depreciation. If somebody's done something to decrease substantially the value, whether it's by bad business decisions or trading decisions or spending money on a paramour. These are all issues that can be considered. Next, which is also a little complex to touch on in here, but the tax consequences of the proposed distribution. Now, what we'll talk about later in the slide is that there's generally no tax consequence to the transfer of your assets into a divorce between spouses, but there will be future tax consequences that need to be considered. And of course, the present value of the property is something you want the court to consider because it's what you're taking. Best determination of value is what it is currently valued. Courts will also look into custody issues. What parent has physical custody? Is there a need for him or her and the children to remain in the residence? Is the residence a pure marital asset, or is there other issues like premarital contributions, postmarital, things we'll talk about in a second. But just know, for the purposes of equitable distribution, the custody arrangements will also be something that the court should consider. Moving on, I have an alarm going off in the background, so I hope that stops and didn't interrupt. Additional things the courts can and should consider when distributing equitable distribution is the debts that each of you have. Obviously, you're going to need to service those debts. They may also encumber property. So not only having the debts and the value of the property, but the need to pay the debts will also influence a court's decision. And probably what I should have mentioned in here, one of these factors are very similar to the alimony factors, and we'll talk a little bit about alimony later. There's a very big overlap between the two, and when you're looking at the distribution of an asset, like a house that may have a mortgage, you're going to have a payment to the mortgage, and the need to make the mortgage payment may impact alimony. So, but we'll get to that in a second. So returning back to equitable distribution criteria, the courts will look at what future issues the spouses may have with regard to medical educational costs of either the spouse or the children, especially if there's special needs to the children. Courts can consider whether or not there was any deferred career goal. Did one parent stay home to take care of a child, which will also impact alimony, but can be used to offset, or can be used as an offset inside of equitable distribution, or at least to be considered. And then the always present and often complicated any other factors that the court may deem relevant. It's kind of a catch-all. Not everybody's circumstances are going to be the same, so the courts will generally have something like that so that any unique situation and unique facts can be contemplated and considered in the distribution of your assets. Now, when you're talking about equitable distribution, it's important to remember it's called equitable, not equal. Now, more often than not in New Jersey, um, it will be equal. And most people, most professionals come from a position that it is going to be equal. But there may be a reason that it should be unequal. And I always caution people, speak to an attorney, find out before you go in, because again, like I said, there's going to be most people are going to presume it's equal. And until you give reason otherwise, they will not consider it. But now conversely, what people will often come to me asking to get an unequal distribution is because they've been paying greater contributions to mortgages or to the upkeep of the house. I generally tell people that unfortunately you cannot reconsider bad decisions when you're married. So if you were significantly paying to a mortgage and you allowed your spouse to spend his or her paycheck as he or she wished, and now you think you should get more of the house because you paid more into it, usually is not going to be the case. Generally speaking, because again, like I said a moment ago, every circumstance is different, but generally speaking, the courts can't reconsider every bad decision that people make because everybody wants to reconsider them. But it's sort of like you acquiesced to this arrangement if you did, especially if you did it for a period of time, a significant period of time. You can't go back and now ask the courts to reverse what you did. Now, I know that I'm giving you kind of conflicting information because on one hand, I'm saying the courts can consider anything and they can consider things that are unique to your situation. But now I'm saying that if you did something like pay your mortgage significantly more, that's not going to be considered. I'm not saying that it never can be considered. I'm saying on average, what I'm speaking to is significant over contributions to a house is not going to be considered an unequal distribution because it is a common occurrence. If there's something uncommon to your situation, that is something that a court can take into account that may not be in these specific statutory criteria. So now inside of equitable distribution, many families, especially in a great divorce, will have real estate and marital residence, and then the ultimate, or not the ultimate, the main decision is, do we keep it? Do we sell it? How do we divide it? Now, obviously, there's going to be a lot of concerns, and not just between you and your spouse, but also you and the market, you and the other economics of your situation. So first thing I always tell clients when you're talking about selling a house is consider the real estate market. Right now in February 2023, interest rates are on the rise. There was an increase or inflation in housing prices following the COVID quarantine. So that's kind of getting a cooling effect because of the increase in interest rates, but the increase in rates making it harder to borrow is going to impact and cause housing prices to decline. That may or may not be the best time for you to sell. There will be other issues that we'll talk about, but inside of that, if there is going to be a consideration of keeping the house or one person buying the other person out, you obviously need to consider the circumstances for that buyout. More often than not, especially when interest rates are on the rise, it's much more challenging for one party to buy out the other party because you typically qualified for the mortgage with the two incomes in the household. Now it's going to be one income in that household. It's going to be difficult. So along those lines, if you are the person that's going to be bought out, you're leaving the house and your spouse is staying in the house, you want to carefully negotiate the provisions regarding the buyout. What will or won't happen, what the time frames are required to be. So for instance, the spouse must sign the deed in 60 days or vacate the residence and you reclaim possession, or it automatically goes up for sale without need to file a motion. Because what will happen a lot of times is you'll have a 90-day provision for a buyout. The 90 days comes and goes and nothing happens. Well, you can't just lock the door or change the locks or take over the house. More often than not, you have to file a motion with the court, which will be heard in 30, 60, 90 days later. Now you're 90, 180 days out in some cases. Sometimes the mortgage isn't being paid and it's in your name. It's destroying your credit. So you have to think about these things in advance and build them into an agreement if you're if you're settling your case, which most divorces do, but even if you're going to a divorce trial, you need to bring these points to a judge and ask that the judge address them if you're not doing it by a settlement. The two spouses, you and your spouse, may also consider whether there's a need to stay in the house for the purpose of the children. Even in great divorces, we do see younger children, high school, college, teenagers, and the need possible for continuity in education can be significant, something that you want to consider, especially if it's a short term. Going back to what I said a moment ago, that you can keep the house. You could, when you consider the housing conditions, you may keep it for a period of time. So that period of time could be until the youngest, finishes high school. That would also allow you to contemplate changes in the market condition that may occur over those years to sort of maximize the return on the value of the house if you're selling it years later. So more issues again with keeping or selling the house, because obviously you're going to be, in many cases, one of the most substantial assets that you have. You need to determine in the process, and hopefully early on to the process, if you're going to need to appraise it and what date you should appraise it from. Typically, it's going to be appraised both at the date of filing as well as at the date of your divorce. This goes to the difference between active and passive assets, which we'll talk about briefly, but I won't go into deeply. Again, I don't want to sound like a broken record, but I do have videos and webinars on those topics. I do suggest that you watch them because the distinction between active and passive is very important, especially in a great divorce, and I'll talk about it in a minute, why that can be. You want to also consider what other assets may generate income. If you're getting taxable interest from an investment, if you're getting rental income from commercial property, obviously these should be factored into not only your distribution considerations for assets, but also into the alimony considerations that we'll talk about in a few minutes. Now, also, when you're talking about a house, keeping or selling a house in a great divorce, there is the issue of whether or not there's an interest in downsizing. More often than not, your kids are grown most of the time. Many times, at least, they're out of the house. You might want to look into a retirement community at 55 or older as a way to reduce your housing costs and maximize the return on the assets that you're distributing in your divorce case. Going back to the kids, whether or not you want to keep them in the house, you want to keep them in the same school district. Like I said a moment ago, continuity in education is often a big concern for parents. If your kids are at an age where they may shortly be leaving the home, because in a great divorce, again, it's more common. This is just something that you need to consider. Again, none of these are going to be required to be considered, but I recommend it that you consider all of them so that you get the best distribution, not just for you, but for your spouse. I mean, it's not in New Jersey, it's not like one person gets everything and the other person loses out, as often as many people want that. It is going to be based on fairness. So in order for you to get a good, fair outcome, your spouse needs to, and you need to make sure that the kids are taken care of. So after the house, the next thing you need to consider usually are going to be how to navigate your investment and retirement accounts. Again, in great divorces, this will largely or often be very large and plentiful, well, not plentiful, but there will often be numerous types of investment and retirement accounts, and often in both sides of the table, on both spouses. Here I lumped together a lot of the information because, again, to go through slide by slide for something that's more of a general topic is going to take up too much time in a webinar like this. But you want to understand how these accounts, and I listed the general ones below: quadros, qualified domestic relations orders, which are court orders to the division of them, of a pension. Then there's pensions, 401ks, IRAs, bank account stocks, mutual funds, other investment accounts. So as I said before, well, one thing to realize is the tax consequence to the transfer, which I said earlier, there is no to the immediate transfer. But one of the issues often in a great divorce is one or more of your retirement accounts may be in pay status. So, and that takes on several different aspects, because if it's in pay status, first of all, now it's an income that may be counted towards alimony, but also may be a marital asset because you may have acquired the pension before pay status while you were married. So now it's a marital asset that might be subject to distribution, and there's an income stream that might be subject to distribution onto income. So you need to just get a hold of these issues when you're deciding how to divide up the accounts. Another consideration is for integrated divorces again is what is marital property when you may have married late in life. So great divorces are usually divorces of people in their like mid to late 50s and beyond. Does not mean that you got married later in life. It may mean that you've been married for a long time, but there's generally going to be one or the other. You've been either married a long time or you married later in life. So either way, you need to consider what is and isn't marital property, but there are going to be different concerns based on the ages that you married and the length of your marriage. So let's take a look at some of the criteria courts will consider when dividing assets in a gray divorce. First, obviously, is going to be the marriage date and the date of your complaint, sort of the starting and ending dates. And again, some will be, again, a third time at the actual divorce. Those will all determine depending on whether or not you have an active or a passive asset. Now, again, I mentioned before there's a separate webinars which I recommend that you review. So simply put, an active asset is one that changes value because of the contributions or efforts of the parties. So you start a business and you're there every day, or you're putting in money to keep the business running. Your spouse may be home taking care of the children at the same time. So that's an active asset. A passive asset is an asset that changes simply because of the passing of time or market conditions. So like an IRA or a stock account that's not actively being traded changes value high and low because the market swings. Now, currently, most judges tell me they consider houses or the marital residence to be a passive asset, which I disagree with, because I think the fact that you're making mortgage payments, you're putting a roof on or capital improvements, you're raising a family, I think that all means active. But they do passive, and I think that's generally because it allows the house to be valued at the time of the divorce, not at the time of separation. So if you file for divorce in 2023, but you don't get the final divorce until 2024, 2025, the asset will change. The value of the asset will change, and maybe substantially. And I think because more often than not, marital homes are a substantial asset of the marriage that they've chosen to look at it this way. So I could argue until I'm blue in the face that it shouldn't be, but I have lost that argument. So for you to be prepared, expect it to be considered passive and gets valued at the date of your divorce also. The concept that's important for active assets is what's called marital momentum. Again, I can't go into it in deep, but that basically is saying that even though you may have had a premarital asset like real estate or business, even more likely, that you'll argue you started before you were married so that there's no reason there should be a marital component to the value. But the concept or the other argument is that the momentum through the marriage is what created substantial volume or value. So let's say you opened a business, a year before you got married, and you had, put in a couple dollars and it was you running your shop. And then over a 10-year marriage, the business grew, you got more clients, you hired staff, you bought assets. Well, that clearly is a marital momentum result because you started with very little and you had very little premarital time or premarital momentum. Now, contrast that with a business that you may open 10 years before you get married. You started it with no money and working out of your shop. And when you get married, you have a commercial building, 10 employees, a lot of goodwill on a customer list. Well, you get married 5 years later, it's going to be much more difficult to determine, did the marital momentum contribute to the increase in the value, or was it simply the premarital momentum? So something very important to take in consideration. One thing to consider even when we're talking about active and passive, premarital and marital, is that there is a rebuttable presumption that both parties contributed to the acquisition and to the increase in value. So while I'm telling you to consider all these things and that the court will, realize that you're going against the presumption that there was unequal contribution. That goes back to what I said earlier about where people like to argue, well, I paid more into the mortgage, so I should get more back. It's just not the case. And if you are trying to take that position, the burden is on you to prove either unequal contribution or premarital exemptions, which we'll talk about more thoroughly in a minute when we go through additional marital property criteria. So let's look at inheritance. So that's a common issue when talking about great divorces. People in their late 50s will have often aging or deceased parents, unfortunately, and inheritance becomes a very significant topic. The things to know about inheritance, the simple versions, one is it is an exempt asset. So if you receive an inheritance, it's exempt unless you commingle it or some other way add it to a marital asset. So if you put the spouse's name on it, if you buy a house and you title it the spouse, these are all value issues of commingling. You may lose the distinction of the exemption. I also recommend, I recommend to everybody, but especially in a gray divorce, that you update your estate plan. Whether you have received an inheritance, but you should also be planning for how you want to leave your inheritance. So let's look at some other marital property criteria that are exempt. Gifts, except for between the spouses, are exempt. So if you get a family gift or actually a family gift is usually the most common. I can't really think of another example of a substantial gift, but you could. Same with inheritance. You have to keep it separate and not commingle it. There is an argument sometimes that it was done for convenience. It's not a good one, and I wouldn't rely on that. If you want to keep property separate, then don't commingle it. As I said before, you can consider a pre or post-nup. Prenuptial agreements are often thought of negatively, and they shouldn't be. And post-nups are usually thought of positively, and they should be considered negatively, and I'll explain briefly why. So a prenup, if it's done right, and again, I have another webinar that you can watch on that for the criteria to make sure that it is. But if it's done right and it's enforced, not only will your rights be determined by the prenup, but you will save yourself a lot of time, money, and stress getting divorced. Now, postnup, which I'm a big fan of, is generally not favored by divorce judges. They consider it coercive. It's sort of like sign this or I'm leaving you. Because a postnup is often called a reconciliation or a mid-marriage agreement. So it's like where you're trying not to get divorced, so you sign it, which I think is a noble attempt. But again, the judges disagree with me, so know that they are not favored. So be familiar with the requirements of both a prenup if you have one, or if you're getting one, and a postnup if you're going to draft one. Next, another big issue in a gray divorce is Social Security. That's hopefully it's going to continue to be around for some time, at least it is currently in 2023. So you need to know what to expect if you are retiring or plan to retire, and you will have Social Security issues. So now, the main thing about Social Security when you're married, and again, this more commonly relevant in a gray divorce, but can be any divorce of over 10 years, is that your spouse or you, either one, you're each automatically entitled to the other's Social Security after 10 years of marriage. And generally, you'll be opting for whomever's Social Security is the larger of the two. So whomever was the higher wage earner during the marriage will likely have the higher Social Security. And then that the other spouse can opt to take a portion of their the other Social Security as opposed to his or her own Social Security. And the fortunate thing, or the unfortunate, I mean, it's fortunate for those receiving it, but what's unfortunate to the system overall is that it doesn't impact the benefits. So if your Social Security is higher than your spouse's, your spouse can opt to share, or your spouse can opt to get Social Security based on your Social Security, but it doesn't reduce your Social Security. So they just get more, which is partly why the system is failing. But right now it's in place and these are the rules, so plan accordingly for them. But no, you both must be at least 62 before you can start to receive these benefits. So let's talk about spousal support in a gray divorce and specifically the alimony factors. And here I'm gonna just zip through them because there's a bunch of them. They are, like I said before, very similar to the equitable distribution. So you have the need and ability to pay, the duration of the marriage, the age, physical and emotional health of the parties, standard of living, earning capacities. These are the main ones. I always say there's 14, and I'll go through this. The first four, I think, are the most important. The ability and needs, the duration, the age and physical health, and the standard of living during your marriage. But again, they don't agree with me. So more are the length of absence from the job market. Generally, if a spouse either stayed home to raise children or was disabled or for whatever reason just may not have been working, will be important. Parental responsibilities for children, if they currently have parental responsibility, or as we said before, if they lost time in the market because of that. Any training that is needed to help the lower earning spouse re-enter the market or raise to a level to be self-supportive. Courts will look significantly to the history of financial and non-financial contributions. And I say non-financial so that spouses who raise children don't get to be homeless because they didn't contribute to the mortgage payments. So obviously raising children is that kind of contribution. The courts will also consider the equitable distribution of your property. Not so much so. I mean, it's in the statute. I don't find courts do that because assets and alimony are usually separate. So, but in some cases where there's substantial assets or substantial income that's going to be derived from these assets, it will impact. And as I just mentioned, so income available through assets will be considered. The tax treatment also of alimony is important. Simply put, it currently is not the tax deduction on the federal level, but it is on the state level. And most people, even most lawyers, miss that point. So make sure that if you're making an agreement that has alimony, that you build these pieces into it or these considerations into it. The courts will consider any penene lite support, which is support that's paid during the course of your marriage. Because what's important for alimony, one of the most important things is alimony generally can't be longer than the term of your marriage unless your marriage was over 20 years. And if you are receiving support during the marriage by court order, which is important, that gets subtracted from the final term. So if you're married 19 years, let's say, unlikely you're going to have alimony beyond 19 years. If you were getting temporary support for a year or two in your divorce, now you're only going to get a max of 17 years, just as by way of example. And of course, the ever-present any other factors that the court may deem relevant. So some of the other things, now that you have the main considerations, which are alimony, equitable distribution, you need to look at some of the, not smaller, but less significant but compelling issues in your divorce. And the first is going to be, do you need to retain employability or other experts for your spouse's earning capacity, generally for alimony? Now, obviously a longer duration will more often, in my experience at least, have the traditional setup where one spouse was out earning, or at least earning significantly more, and one spouse was staying home with the children. So you may need to have an employability so you can talk about that lower earning spouse's ability to earn now. You may need an expert also for lifestyle analysis and levels. As I mentioned before, the alimony statute was revised. Well, actually, I didn't mention it was revised, but I mentioned that you can't have permanent alimony of 20 years or less. They actually removed that word, permanent alimony. They also added in modifications for retirement and cohabitation. So again, when you're looking at the discussion of do you need employability or other experts, you want to look at the different types of alimony. So I'm listing them here. Open durational, limited duration, there's rehabilitative, reimbursement. I actually have to take a pause. I'm going to leave the recording on, but I have an issue I got to address in the house. So give me 1 second. I will be right back. I apologize if you're watching this on the recording, but I don't know how far ahead you'll have to advance. Okay, sorry, I'm back. Probably only a couple minutes of delay. Apologize for that. Hopefully no more interruptions. So going back, we were talking about the different types of alimony. I know I sound like a broken record. I do have a webinar. Not only I have one on the different types of alimony, but I also have one on the Alimony Reform Act of 2014. I would recommend watching both, if not more, then at least two to be fully familiar with all these issues. Going back to considerations about experts, some cases you need a forensic expert if there's a business or self-employed. Even if it's like somebody who's just 1099, a computer or consultant, you may need to know both revenue, if their expenses are being covered, their personal expenses are being covered as business expenses. You may need to look at goodwill and how much value they have. So even a small business will need an evaluation. So another issue, big issue with great divorces is obviously going to be retirement and building planning for that. Fortunately, the alimony statute, as revised in 2014, now contemplates a good faith retirement at federal age of retirement. So let's first look at the provision, and then we'll talk a little bit about it. So there's a rebuttable presumption that alimony terminates when you attain full retirement age, except the rears do not. Now, that's important because full retirement age doesn't necessarily mean 65 or 67. That's more often than not, what is being considered. But, police officers, firemen, they're in for 20 years. If they started when they were 20, 22, they're retiring at 40, 42, 45, 50 sometimes. So, and that's not necessarily improper because of the difficulty and stress and risks that they take. So you can retire prematurely, but you will then have the burden of proving that it's a good faith retirement. If you retire at the full retirement age, then you're presumed to be doing so in good faith, and the burden is on the other party to show otherwise. So how do you overcome that presumption? There are certain factors that the court will look to. Again, they'll look at the age of the parties at the time of this application for retirement. They'll look at the age of the parties at the time of the marriage and at the time of the alimony award. They'll also look at the length of the economic dependency. How long was one spouse earning less or out of the workforce? And did that impact the retirement age of either party? Have they relinquished other rights or properties in exchange for longer alimony? So if one spouse, for instance, gave up a pension and got alimony, or gave up interest in the house for alimony, and then the other person retires and retires prematurely, or even actually at full retirement age, courts still can't consider if there was an agreement to get more alimony to give up something, it might be considered unfair to terminate alimony under the rebuttable presumption. Obviously, they'll look at the duration of alimony already paid. Now, I'm going to just leave this here. Duration of alimony, health of the parties, the assets, whether the recipient's full retirement age, sources of income, ability for the recipient to have saved, which is important, and any other factors the court requires or deems relevant. I put these up again. I don't want to go slide by slide for every single small thing, but the one important thing here is the ability for the recipient to have saved adequately for retirement. That's going to be important both if that person is trying to make a rebuttable presumption overturned and say that retiring at full age is not appropriate. I think it's also going to be relevant if I'm just saying you, for instance, if you're the one who is retired prematurely and you're trying to have the court find that it's a good faith retirement at a younger age, I think the courts are still going to look at whether or not the recipient did have sufficient time to save for planning. Now, depending on where you are in that argument depends on how impactful it will be. If you're at good faith retirement at full retirement age and the recipient has had sufficient time to plan and has not, it won't hurt. But if you're retiring prematurely and you're robbing the recipient of many years to save for retirement, that will cut against you. So how do you handle these issues? And this is important with any agreement, but especially with alimony. I touched on it a little bit with the house, but you want to be specific in your agreement, because I go on the assumption that most divorces are settling by an agreement. 99% of them do. The 1% that go, I think like 98% of those settle during the divorce hearing. So you need to build these things in. If you're going to be retiring prematurely, or you're in the kind of profession that typically one does, you want to mention that. You want to put in the year that you're going to retire. You want to put in what triggers and what proofs are required, and what there's a process. Do we have to file a motion or not? Just like I said when it comes to selling the house. Don't rely, and this is important, don't rely on the fact that the statutes say A, B, and C, because if you make an agreement and your agreement doesn't say A, B, and C, the statutes may not apply. So you're not going to have you're not going to be bound by the same laws if you don't either cite to the statute and say it's included, or specifically indicate that all those provisions are included. Another thing to watch out is what I call double dipping, when there's issues of retirement accounts or interest income, real estate producing income, pensions, very important. If you're getting a pension that's in pay status and they're considering it for alimony, but you're dividing a pension as an asset, you need to make sure, first of all, that the difference will be accounted for, because when you divide the pension, your income will go down. But you also don't want to have them count both the income from the asset as an asset and the income from it as part of alimony calculations. It's a complicated issue. I'm not going to go into it here, but it is something you need to be mindful of, and you do need to either talk to an attorney or watch some webinars if you have that issue in your case. A couple other things to think about when we're talking about alimony and retirement is there going to be cohabitation. Now, with the reform of alimony, the cohabitation clause was also modified, so it can be suspended or terminated if there's cohabitation. Cohabitation is defined as a mutually supportive, intimate personal relationship in which the couple is undertaking privileges and duties commonly associated with marriage. So what does that really mean? So if you're going to be asserting that there's cohabitation, the things that you want to show to a court, intertwined finances like joint bank accounts, joint debts, credit cards, payment of bills, shared responsibility for these living expenses, which is challenging because it's hard to get into banking issues and prove who's paying what, absent like a private investigator or some discovery, but that's a different process. The recognition of the relationship in social and family circles, and yes, that does mean social media. The frequency of contact, the nature of the relationship, how often they are together, whether they're living together or not, how much time do they spend together. When they are together, are they sharing household chores? Is one taking out the garbage? Is somebody painting the roof? And then also, if the recipient of your alimony, let's say, has a promise to be supported by another, like a palimony, for instance, palimony claim, or a promise of marriage. That's also something important to consider. And I don't know if that's specifically in the statute or not, but it's something I always urge to find out. Even if they did in social media or they made statements in front of other people or children, I think, not that it's enforceable, but it certainly goes to the nature of the relationship. And then, of course, all other relevant evidence. So how do you put all this together? The court's going to consider all these factors, even if they don't live together on a full-time basis. Proving how much time together usually requires either testimony or a private investigator, but it doesn't have to be 7 days a week. It doesn't have to be every weekend, but it does need to be a sort of regular pattern to suggest that there's a ongoing relationship. Now, what I usually recommend is agreeing to a clause that says what is cohabitation and whether it ends or modifies support. Because what happens under the law is, first, I don't know if it says it gets terminated or modified or both, but it can be reinstated if the cohabitation ends. So you could go through all this, prove your spouse is cohabitating, terminate your alimony, and then the spouse terminates living with that person and seeks to have alimony reinstated. Now, I've never seen it actually happen, but the law allows for it. So you might want to put a provision that says if there's cohabitation, alimony is terminated. If it's terminated, it cannot be reinstated, for instance. You can deviate in your agreement from what the statute says. Other things when you're planning for retirement, obviously insurance needs are important, private health insurance, yours and your spouse's. If there's children, you may want to also look at life insurance. If you have young children for college, if you have an alimony obligation. In gray divorces, it's more challenging to get these kinds of policies because the age and health requirements are usually more significant. So other than health insurance and long-term health care, which I actually didn't touch upon, not much greater needs for insurance planning in divorces other than that. So that would really lead us to just questions. If you have any questions, you can submit them to my email, which is brad@micklinlawgroup.com. That's MICKLINLAWGRUP.com. I do my best to address them. If you do, first of all, I can't address everything, and I don't always get to address everything. I also don't get everybody's emails. Sometimes they're put in the spam or junk. It's important to know if I do answer it that we're not creating an attorney-client relationship. That's just a catch-all I always got to include. And with that, I hope this information helps you. Again, I urge you to go to my YouTube page and my website for more information, more detailed information. And I wish you all the best of luck. Be safe.